Good morning, ladies and gentlemen. Welcome to the CICV Forum webinar. Thank you very much for joining. We've got a big number on today, which is tremendous. The subject today is extension of time and loss and expense. Just to mention that the future seminars are also shown on the CICV Forum website. We've two to go. In a fortnight's time, we'll be looking at suspension and termination, and then we'll finish off with a session on conflict avoidance. We're also looking at running some more seminars into the early part of 2021, possibly a Q&A session with the 5 presenters, and then on NEC 3 and 4 as well. For those of you who have missed the previous webinars, you can access the forum website and you can see these, play these with your colleagues and share the experience of that. If you want to book for the future seminars, you can do that through the website. Now, just one thing to mention before we rock and roll in this. At the last session on payment, we discussed at length the provision of a payment schedule. And I'm glad to say that that is now on the CICV Forum website. It's guidance, but it's recommended that employers, contractors, and the supply chain use that to bring certainty of to the payment dates in relation to payment applications. And if the industry collectively signs up to that, we are convinced it will reduce the number of disputes that arise in relation to whether or not an application's been made in time and have the various other documents been issued. So it's well recommended that you use that. I'd like to thank Angus, a presenter here, and also Ian Honeyman for the tremendous work that they've put into that. Today's webinar is going to be slightly different because all three of us will be participating in the discussion on EOT and loss and expense. From my perspective, I would like to talk about some of the issues that I experience as an adjudicator. Ian will be touching on issues from the main contractor's viewpoint, and Angus in relation to the supply chain. You'll see at the bottom of the screen there a little doofer that you can put in a question, and we'll deal with these at the end of the session. So if you have any burning issues, please put these into us, and hopefully we'll have enough time to deal with these. I'd also like to thank our communications team who set these webinars up. The presentations have been very, very well received, and we're delighted at the feedback that we've had. One thing just to mention before we launch into this, Ian and Gus and I yesterday were speaking about collaboration, and we remain convinced if there's a higher level of collaboration in the construction industry, then an awful lot of the problems that we have with extension of time claims and loss and expense claims can go away. And we'll touch on these in a moment. So I'm sure you're familiar with the presenters now. In the middle of Ian Honeyman, Commercial Director of Scottish Building Employers Federation, and Angus Pearson, who's a Director of Fortis Contracts, who's got, so he tells me anyway, an incredible level of experience in dealing with construction claims. Angus is actually joining us from this palatial house of Rhodes. Nice to make yourself available. Now, I'm not going to say too much about the forum because I'm sure our regular listeners will be aware of what the forum is all about and what we're doing. At the present moment, there's a number of issues happening. We're looking at the development of conflict avoidance processes. We're looking at the development of project bank accounts and bringing these into the industry. We'll be developing these training modules. We're also looking at various issues in relation to procurement, employment issues, and we will be looking soon at the development of a quality protocol for the industry. And last but not least, we're dealing with the daunting subject of Brexit. So that's what we're involved in at the present moment. Now, I want to start off by saying, from my perspective, an awful lot of claims fail due to the absence of proper notices and a failure to provide substantiation. And if you're dealing with an extension of time situation, if you don't deal with these things properly, then you will be subject to the application of liquidate and ascertain damages. So it's very important that you deal properly with all of these issues, and we'll touch on these in a few moments. So what is the key to all of this? Well, you've probably all heard this hundreds of times: records, records, and records. There's absolutely no substitute for having very detailed records regarding the history and progress of your construction project. And these records can come in various guises. You've got communications between the parties, electronic communications, notices, requests for information. When were these requested? When were they received? Is there an information release schedule in the contract? If you look at the fifth recital in the 2016 SBCC conditions, you'll see that you can either have or not have an information release schedule. And if you look at clauses 2.11 and 2.12, these will also show you the flow of information that has to come from the design team to the contractor in order that the contractor can progress the works regularly. So information schedule is a very important part of your armory in running a construction project. Daily resource records, these are absolutely critical. Labour, plant and material. A weekly review of plan versus actual progress compared with the programme. Let me just pause for a moment to say this is where I see a big weakness in the industry. If a contractor is in delay, I strongly believe that the design team and the contractor should work closely together to monitor the delay and the effect of delay. So have that discussion at the time. Don't have it 18 months later when you appear in front of me with a construction claim. And this is the important thing that Ian will be mentioning later about collaboration. Deal with things at the time and don't deal with them at a later date. Another issue is what caused the delay. What's the source of delay? And what is the impact on the progress of the project? Now, there are various ways that you can record information. We're seeing a greater use of videos. We're seeing a greater use of photographs taken at the time. And the contractor would be advised, and the subcontractors, to write a legend of what is actually happening on site at the time, and also identify the personnel that were going to be involved. So that sort of information, our advice is that you should share that so that we act as grown-ups. We realise that the contractor is in delay for whatever circumstances, and that delay should be properly monitored. One other issue is that quite often personnel leave the organisation, and if you find that 12 months later you're submitting a claim or been down the route of an adjudication, the key individuals that were on the project have disappeared into the sunset. They've gone away to work for somebody else. They might not be readily available. They might not want to cooperate. So that's why it's very important that you properly record issues as and when they happen on site. Quite often see a failure to record disruption, and we'll be talking in a bit more detail as to what that actually means. But where the contractor is going along, progressing the job, and he's deflected from that for circumstances out with his control, then it's essential that you monitor all of that. And finally, a design team contractor collaboration. That is essential to resolve issues, and we'll be mentioning that all the time during this seminar. Work far more closely together instead of being at opposite ends of the spectrum. Now, I'm going to hand over to Ian now to deal with some issues regarding monitoring progress. Ian?
Thanks, Len. As you'll see on the screen and the slides there, monitoring progress is probably one of the most critical aspects of dealing with the project and identifying where projects and such like can sometimes come off the rails. Now, the main mechanism for doing that is obviously measuring it against a program, whether that be a master program, a tender program, or otherwise. But the program is basically the fundamental tool that identifies what the thought process was on the project before we started, and effectively is the process that we have to put in place beforehand. Now, when we start a job, and it really comes back to the tender, when you're asked to submit a tender, 9 times out of 10, you may or may not be asked to put in an actual tender program. you'll be given effectively a start date, usually a duration, and usually that will generate a completion date. And it's pretty evident from the outset that when contractors are faced with that, they look at the work that's got to be done, and generally they end up fitting a program in that works around the duration that's been stated in there. Now that can be fine, but it can also be a fundamental flaw, because who is it that actually puts that program period together, and what's the reason for the end date being there? If the work scope that you're trying to do is going to be way beyond the duration, I think it's quite important that that's identified during the tender process, because if you submit your tender based on the fact that you can do a job in 12 months, for argument's sake, but when you sit down and look at the program, you find out that you can't do it in 12 months, it's going to be 14. By the time you're potentially in contract, you'll be stuck with that, and it becomes a bit more difficult to argue otherwise. So you've got to be careful when you're doing this. Tender documents, they ask for a lot of information in terms of the price and all the rest of the stuff, but it is another important thing. Most contractors will probably sit down and work out a program, but it's a brave contractor that puts forward a tender saying that they can't complete it within the dates that's given. But they need to be aware that if they're doing that, if it's going to be something a problem, you know you're going to be faced with that once you come in. A lot of our problems that we see in industry is that contractors sign up to those contract periods and think, well, once I'm in contract, I can argue the toss about how much time is going to get added because I'm going to have a claim. Entering into a contract on that is a very risky strategy, because you can fall foul of things further down the line. One thing to remember, at tender stage, not everyone's going to be known. So if you pick up something in the tender that you think could be a problem, it's important you flag it up, and it's important you flag it up probably before you're into contract, and certainly have that conversation with the client if you're asked to come around the table and do that. These things should be kind of resolved with the employer before you start a job, because if you don't, you know it's going to be a problem once you're in contract, and by that time you're then up working under where you're supposedly back against the wall in that stage, which is not a great place to be for either the employer or the contractor, and indeed the subcontractors further down the line. So under SBCC, there's a requirement to basically produce a master program. Interesting thing with master program is it's generally asked for after the execution and acceptance of the contract, and it's basically based on the principle that the design team will have issued further information over and above that was available at the tender stage. And at that point, the contractor is asked to pull together a master program that will be used for the monitoring of the program and the works as the works goes forward. That program is pretty critical. It's critical that you get it as near accurate as you can based on the information you've got. And it should identify the critical paths and activities that are there that govern the progress of the job. Because if anything happens on that critical path, I'm sure you're all aware, then obviously the end date is going to be affected no matter what you do. You could end up spending a lot more money to get it back in time, but that adds into the potential issue about loss and expense. You should identify any key dates for the information, when information is going to be required, key dates in terms of tying up large material orders or placing subcontracts, etc. Identify any long lead-in times on any items and materials or potentially subcontractor work. The next item on that list, contractor design packages. That has become a significantly more problematic area for the industry in recent years. And that's mainly because the design element of it lies potentially with the main contractor and the subcontractor to pull together. And the timing of that is absolutely critical, because where that particular package fits within the overall program, there may be aspects that need to be sorted out very, very early on. And if you're left till late, it comes back and you've got a problem, because you can't then go back and revisit something that could have been done earlier. Two other areas in there, and Gus and ourselves were having a discussion the other day about defined and undefined provisional sums. Any provisional sums within a document potentially pose a program issue in terms of when you can fit those particular items in, and whether or not the sum of money that's allowed reflects the volume and extent of the works that's got to be done. So there's an object there to be looking at it. If it's classified as a defined provisional sum, you've got to allow a period of time in your program for it. If it's undefined, it's kind of left floating. the best thing to try and do is try to eliminate provisional sums altogether, but I realise that's not necessarily they can do it. The master programs is then used to effectively monitor progress, but it's important that that master program is accepted by all parties to the contract, because if it's not, then it just becomes another piece of paper that becomes a bit of a debate. But if both parties are effectively sitting down and looking and reviewing that program on a regular basis, then we can see where pitfalls come out. But it's important that both contractor, subcontractors and employers, representatives and design team are upfront and honest about where they are in relation to that, because basically ignoring a problem early on is only going to be a problem that's generated further down the line. It's important that if you identify an issue, have the discussion and try to resolve it at that particular point in time, because anything you put into the long grass is just going to be a problem for further down the line. The issue about whether a master program is a contract document, if it's generally speaking, if it's issued after the tender, it's unlikely to be classified as a contract document, but it can be adopted as such by issue of an instruction or the like, in terms of basically saying this is the master program. SBCC contracts are slightly different, or NEC. NEC, the program is a significantly more important document and a more used document, and it's a bit more floating. It moves about in terms of that, but it's used more of a tool to do this. But as I say, the master program in any contract is kind of fundamental to this whole process.
Okay, thank you very much. Now, in the last session, we spoke at length about the importance of complying with the notice provisions in a contract. And I've had a number of adjudications over the past 20 years where there's been a showstopper argument. The contractor didn't submit a notice on time, and that effectively stopped the process. So this is another area where the industry has got to get its act together. And it's essential that you follow the notice provisions in the contract. And I've identified the clauses in SBC 2016 that you have to comply with. And what you have to think about is, when have you to issue the notice? Who have you to send it to? How have you to dispatch it? And what are the contents of it? If a notice says that it's to be sent to the site, it's to be sent to the commercial director of the company, and I saw one recently where it said it had to be sent to the chief finance officer, then that is what you have got to do. So make sure you understand from the outset what the notice provisions are and make sure you comply with them. We would encourage contracting organisations to have a kind of standard form of notice that reflects the notice provisions in the contract. Gus, can I just bring you in for a minute here in relation to down the supply chain, the type of wobblers that you might experience?
Yeah, we'll be coming on to that in a later slide anyway, but the standard form, normally you notice there's a clause in there that will tell you what both parties have to do in relation to notices. It's normally sent to the address in the contract or the last known business address. When you get into subcontracts, it can be a good bit more sort of prescriptive. You know, it'll give you deemed means of service, whether that be hand delivered, courier, sometimes by fax. Even in this day and age, quite often you'll see email notices specifically excluded. And they can get quite heavily prescriptive as to the type of content that must be in the notice. Quite often you'll see a part 2, a follow-up that's a requirement. So subcontracts tend to be a little bit heavier, and there may well be shorter timescales for submitting those notices and things, but we'll swing back onto that when we look at subcontractors' claims for loss and expense.
Thank you. Just to give folks a bit of an anecdote, I had an adjudication not so long ago, and evidence was being given by Mr. Bloggs. I think this contractor is a claims-conscious contractor. And I said, well, why is that? Because he keeps giving me notices of delay. I said, okay. Is that not what the contract says he should do? He said, yeah, I suppose so. But we're getting them every day of the week. So, you know, that was a ridiculous attitude to adopt. The contract says that you're entitled to give notices. Give the notices. You can't be faulted for that. Anyway, let's move on to the guts of this, fixing the completion date. And if you haven't done so, you want to make yourselves familiar with clauses 228 and 229 of the 2016 edition. Perfectly straightforward to read. You just need to get an understanding of them. So first of all, you've got to give a notice. You've got to give the expected effects and expected delays. And quite often that's very difficult to forecast at the early stages of a contract. And it shouldn't be knocked out for that reason. It's something that you might be needing to update constantly. And again, if we're going to live in a grown-up world and change our industry in Scotland, let's have some engagement between the contractor, the employer, and the design team, and face up to the realities of it. And as I say, monitor it so that there's no disagreement later on. So you then need to move on to the action needed by the architect. He's got to decide, is it a relevant event? Is a delay likely? And is the completion date affected? And if so, you award an EOT within 12 weeks of receipt of the required particulars. I am an advocate of reducing that 12-week period. I don't see that that is necessary, in all honesty, and we'll come on later on to the anomaly with loss and expense. I would like to see that being brought back to a more realistic figure. So what can the CA do? He can either decide is an EOT, and he states the relevant event that he considers it should be based on, and he fixes a later completion date or not, as the case may be. Now, you then want to look at the further provisions in the contract. After the first fixing of the completion date, an earlier completion date can be granted having regard to any relevant omissions. And clause 226.3, I'll just look it up just now, that defines relevant omissions, and that's to do with variations under clause 314 or through an instruction in regard to a provisional sum. So as an example, if it was decided to take a provisional sum out after the first fix of the completion date, that would need to be taken into consideration. And you then move on next on to the final review period, which is 12 weeks after practical completion, where the architect or the CA carries out a complete review of everything, whether it's been notified by the contractor or not, and decides either to stick with it already decided or change it, etc., or even grant a longer period. So during that period, I would expect to see a lot of engagement between the employer and the contractor to discuss these things. If you look at NEC, early warning processes, I think, are absolutely critical, and there's no problem in bringing that kind of intellectual thinking to the standard contracts as well. And for the fourth time, I'll mention the need for collaboration. Now, there are 15 relevant events in the SBC contract that may apply, assuming there are no amendments. I'm not going to go into these, they're perfectly straightforward. Quite often see an extension of time claim where the contractor will apply a number of relevant events to the same circumstances, because there could be a whole load of factors that come into play. That's not unusual. One important one is the suspension of the contractor's obligations under clause 413. If the contractor is not paid by the final date for payment, he's got to issue a notice, and then he can suspend all or any of his obligations, and he would be entitled to get time and money. Now, if you think about it, that is an absolutely critical provision in the contract, because the contractor, for example, could be going in to carry out commissioning, he's not been paid, and he says, I'm going to suspend. So that is quite a powerful weapon in the armory of the supply chain to bring in, and the contractor and the supply chain. Now, just one final point of some new stuff that's coming forward. I'll ask Ian to come in here in a moment. This relates to what's known as COVID clauses. A number of public sector organisations have now defined COVID-19 as a relevant event, but not a relevant matter. So the contractor gets relief from damages, but no money. and Scottish local authorities seem to be taking a consistent position, time but no money. Ian, can I ask you maybe just to pop in and give us your thoughts on the equity of time but no money?
Yeah, I mean, I suppose it comes back to the scenario we had when we had a lockdown and everybody was effectively prevented from or told they weren't to work. And you can understand that has an impact on both the client and the contractor and the subcontractor supply chain. And generally it was classified as being the sort of force majeure event, therefore you got time but no money. And that was generally thought to be potentially an equitable way of doing it, but it turns out that's not necessarily the case, because ultimately there's different costs for different individual organisations, and the cost of shutting the site down and the cost for reopening and remobilising under new conditions and such like bring different aspects to that for all sorts of different parties. To be fair, the Scottish Futures Trust, and I know that's maybe slightly different because of the type of work that they're working on, and it's a government procured work. They've adopted a very much a collaborative approach on this and have effectively accepted the principle that there is going to be time and money, but reasonable money. It's basically looked at from a fair and equitable basis. And I think that's basically the way to try and approach it. But obviously, every client and every contractor's got different issues. Clients don't have a bottomless pit of money either. But I think the important thing is to try and sit down and actually agree things that's practical and effectively that you can actually work together. I don't think any contractor or subcontractor is expected to get every single penny that they spent over this period of time. But I think it wouldn't be unreasonable to expect some kind of contribution towards it, because it's at the end of the day, the potential is for either these parties to go bust, and that's going to leave an even bigger problem for a client to complete the jobs and such like. So I think there's a bit of dialogue that needs to happen. Putting the shutters up at the very beginning and basically leaving it that way is only going to create problems further down the line. So I think in some of the earlier webinars that we had on the subject, I think we basically were encouraging people to have a discussion and try and approach it practically. But as I say, there's no one size fits all to that. I think everybody should be having the conversation with their clients and supply chain all the way down to try and bring some kind of sense to the whole thing.
Okay. Gus, you had an experience recently you shared with us of a client of yours was being asked to sign up to a pretty onerous condition. Is that right?
No, Len, I don't have any such recollection. Yeah, we had a contract that came through the office where there was a COVID clause, and it basically was in the terms that yourself and Ian have discussed, where it was a relevant event but not a relevant matter. So, as we say, there was relief from damages but no compensation. Where it went a step further was that it gave the employer enhanced rights of suspension of their obligations and the contract for an inordinate period of time. I think it was up to something like 9 months, where they could discontinue their obligations under the contract. Now, what are their obligations? Well, primarily the big one is payment. So that contract was stacked in a way that the contractor would not necessarily have received any further payments until that event had passed. So unusual, but you see a fair old mixed bag out there at the moment while people are still drafting these clauses.
Yeah, okay, thank you. Just to get my own back on you, Gus, somebody's just come into your flat and stolen your television set. Anyway, there's one provision that we all saw recently, which was a bit weird. It said in there that if, as a result of COVID-19 issues, the employer and the contract administrator are unable to function, then the contractor gets no costs and the project could be suspended for up to 6 months. Now, that to us was an unworkable provision. I mean, it's a massive amount of risk transfer. What they're effectively saying, the design team can't work because of COVID outbreaks in their offices or something like that. So we need an awful lot of engagement in the industry to face up to this and work our way around it. As Ian has mentioned, the SFT, their provisions, I think, very fair. But I think the most important message really is facing up to what your subcontract says. And at that point in time, Angus is going to talk about issues down the supply chain.
Thanks, Len. So much of what we've been discussing so far relates to the standard contract, and as many of the participants will know, most of the contracts they see may be subcontracts, maybe bespoke terms, and they're not always as clean and utopian as the standard form in its unamended iteration. So there's a few things that you have to really be quite careful of when you're looking at a subcontract document. The first thing you should really look for is, do I have an entitlement to claim for extension of time and compensation? Quite often subcontracts can be silent on that. And if you have got a mechanism in there, what circumstances does the contract allow you to make that claim? So quite often it can be tied to main contract conditions where you as a subcontractor may only be entitled to extension of time for the same reasons and to the same extent that the main contractor receives under the main contract. But you've then got to consider the circumstances. What happens if the main contractor is the cause of delay or another subcontractor is the cause of delay? So you need to just check that you've got that right somewhere in the contract. Quite often it's unusual because you see subcontract terms that don't give the subcontractor the right to claim for extension of time. But equally, if they cause delay, they're liable for costs for not only the LEDs under the main contract, sometimes general damages, meaning the contractor's costs on top of that, and possibly any other subcontracted costs. So be careful, read your contract, have a look, see, just understand what basis can I make a claim for extension of time and will it be compensated? You can always negotiate those terms, think about it. The other one is condition precedent clauses. As Len said right at the start, that can quite often be a showstopper when it comes to formulating the claim itself. Typically, you might say, you might read in the contract, within 5 days of the event becoming apparent, thou shalt notify the contractor in blood by carrier pigeon, must be sent at midnight on a Tuesday, setting out the precise cause and an estimate of the time involved and all the rest of it. So you have to, again, be very aware of what the notice requirements are, what's the method of service, what content has to go in there, who are you sending it to? And if there is a time limit on it, and particularly where it says it shall be a condition precedent to any entitlement to time or relief or money, then you better be pretty sure that you're going to comply with that. As we say at the end there, there's no going back. If you miss the time limits, you're very likely to concede your rights to the claim. Regular updates of the extent of delay with costs where you can. Again, some contracts you'll see that this is what I call a part 2 notice. Sometimes you'll see you notify the event within 5 days, and then within, let's say, 14 days, you have a further obligation to advise the contractor of where you think the delay is at that point in time and give them an indication of costs. Now, it is very difficult because you don't know at that point in time what the extent of the delay is going to be until, say, it was you were restricted in accessing a portion of the site. Well, if you're not going to get into that part of the site for 2 months, how do you say at day 14 what that delay is? But if it's a condition precedent and it's a requirement that you give that notice, you better give that notice and just put in an estimate. Tick the box, provide the notice. It may not be accurate. Of course, if you can be accurate in your estimates, by all means, that's the time to do it. And keep updating your programs and resubmitting those. Just showing the impacts of the delay and delay events that you have on your program. And there's no harm in all the documents and videos and photographs, anything else you have, submit those at regular intervals to the main contractor, even if it's under the glib heading of "for your information and records." It's important that everybody's informed. They can then react to the circumstances. Remember, the whole point of the notice provisions and the record keeping, the notice allows you to avoid the delay, allows the contractor the opportunity to clear whatever that impediment is to your works as a subcontractor. So that's the primary function of it. I've said it before, it's not always a starting pistol for a claim. So use it, talk with the contractor, design team engagement if you need to, but try and avoid the delay altogether, because it's grief all round and you're put to some quite draconian measures at times to verify and validate your claim. There's a lot of good soft document systems there, project collaboration platforms now that quite often there's document controllers involved in some of the larger projects. So it's always good to utilize those.
Okay, thank you. So just to summarize, make sure you give your notices, make sure you provide as much record information and substantiation as you can. People have moved on. Recognize as well that there is culpable delay. I've never ever worked on a project where the contractor has not delayed due to his own default. So that's got to be taken into consideration and should be recognized. I want to mention the use of planning experts and delay experts, because I've seen them in all sorts of shapes and guises, and it's a bit of a mysterious world to me, because you've got two planning experts that get the same information on the same project, maybe from different people, and they come up with a diametrically opposed view as to what the delay is. Now, adjudicators are perfectly capable of doing that exercise for themselves. And I often feel that these planning experts, it's a bit one-sided, because they've had an engagement with their own side, but they haven't had an engagement with the other side. So I can't really see how an expert could give a balanced view, but that's the sort of work that adjudicators have got to do. They've got to get in about it. Another thing to avoid, you quite often see in submission documents, we were considerably delayed or delayed considerably. That doesn't take me anywhere. We were completely disrupted. Oh, thanks very much, but that doesn't help your case at all. You're going to have to be much more detailed in your submissions. So let's move on to the last section of this, loss and expense. Again, critical to follow the notice provisions in clauses 1, 7 and 420. Contractors entitled to loss and expense due to deferment and possession, and if regular progress has been or is likely to be affected by any relevant matters. So that's really the contractor looking into the horizon and saying, something's happened here. It's likely to impact on our progress. We can't tell you exactly at this stage. So I'm going to throw this one in. I didn't ask my two colleagues about this yesterday. Ian, how would you benchmark regular progress on a project?
That sounds like an old exam question. Effectively, regular progress and such like is obviously going to be initially looked back on the program side of things. But part of that progress is also having the ability to identify what the resources that were allocated in the original tender, i.e. what was allowed, and you have a breakdown or a backup to support that information. Most of that will come from a tender submission, obviously depending on the size of the project and the individual contractor. The details may be a bit different, but certainly in larger projects there'll be a breakdown of the allowance that was priced in the tender and outputs on that process. Now, if you have a program and you're measuring that and you're seeing that you anticipated completing certain activities within a specified period of time and it's taken twice as long, there's two things with that. Either you got the original allowance wrong, or something has happened to increase the resource required or to take longer. And it's a question of actually having the information there and actually be able to demonstrate that this is what's come in. Had this not happened, we would have been able to complete it on time. But it is about compiling the records and monitoring it regularly, because if something happens, trying to go back and prove it retrospectively is a lot harder than if you're flagging it up as it's happening. And that's why I'm saying it's important to have that conversation and dialogue as soon as possible with the client, whether that's a main contractor from a subcontractor's point of view or the client and the main contractor. It's important to have those conversations early so that you can either address the issue at that point rather than wait until it's manifested itself in a significant delay. But the only way that I can see doing it that way is to have the conversation at the appropriate time and deal with it. I don't know if that answers your question, Len, but it isn't an easy thing to do.
Yeah, no, I agree with you. So we've got 5 relevant matters in clause 422, and just an important distinction, not every relevant event attracts loss and expense. So you need to distinguish from these. Quite useful to set up a little table that sets out the relevant event and sit beside it the relevant matter that applies if it does. So the contractor's got to notify, as soon as he's aware of effect on regular progress. And this is where we run into issues now. The contractor's got to provide full particulars of initial assessment of loss and expense, and it must be substantiated and must be completely updated. Now, an interesting change in 2016 was that there is now a time period of 28 days for the architect or CA to advise the contractor of the assessment, and importantly, to identify differences between that assessment and the contractor's initial assessment and add that to certification. So our message is, Lord Denning said 80 years ago, cash flow is the lifeblood of the construction industry. If it's accepted that the contractor is delayed, and if the QS is reasonably satisfied that the figures have been justified, then make an on-account payment. Don't be too pedantic about it. It's not a surgical exercise, but nonetheless, for you contractors that are listening in, you have to provide detailed substantiation. And you'll see there that the contractor gets paid 14 days after each subsequent update. So that change in 2016 has been of great benefit to the construction industry. Now, Ian and I discussed this the other day, a bit of an anomaly. How come it takes 12 weeks to ascertain EOT, that the loss and expense must be evaluated in 28 days? It appears to us that these are completely out of sync, because our quantity surveyor might say, well, I can't actually allow any loss and expense because the contractor hasn't, the architect hasn't decided on an extension of time. Ian, do you think that's maybe an issue that needs to be looked at by JCT in the future?
I would say it's something that needs to be thought about. Yes, I mean, there's probably is reasons for it, and it's probably because there's 15 odd reasons for extensions of time, but not necessarily with costs. But I think that anomaly is something that I think has to be reviewed, mainly because the decision about paying any extra money, as you say, can end up being delayed. And if it is, as we recognise, cash is the lifeblood. If we're effectively preventing somebody being able to assess a loss and expense because another bit of paperwork in the chain has been, takes slightly longer, then obviously that the mechanism for changing it in the 2016 version has caused an anomaly that probably should be looked at, in my view anyway, because I think that is an issue, because the genuine figure for the loss and expense and such like tends to be as a result of an extension to the programme, not just because of disruption and everything else. But that's I think it is something that we need to probably have another look at and see if we can tidy that up.
If I could just come in there, we've had a question from one of the participants, and it's for yourself, Ian, and it's on the subject of delays. The question is, what happens if your contractor does not identify a critical path or any key dates? How can the delays be identified? Now, I know that relates to the sections we were discussing earlier, but if you have a go at that one, Ian, thanks.
Oh, well, absolutely. I mean, effectively, the whole point about having a programme with a critical path and such like identifying it is there for two purposes. If the programme's there for both parties to use as a monitoring tool, it makes sense to have it. if you don't have it, it becomes more difficult to monitor where the progress and such like is being delayed or otherwise. But you still have time slots on the program. The critical path, depending on where a delay might occur, can move. It's just if the delay happens on the critical path based on the original program, the real master program, then ultimately the end effect's going to have a delay and shunt the end date out unless you put in additional acceleration measures and such like and spend more money to try and bring things back. But when you haven't got a critical path on it, the process is you've got to follow the logic of the original program and basically move the bars for the activities that's delayed out and see how that affects the next one. It's not the best way of doing it, but it's a way that you can demonstrate there. The argument with it comes back as to whether or not the bars and the time period allowed for each activity was right in the first place. But that's why it's important for both parties to sign up to it. If both parties basically, thanks for that program, but I'm going to ignore it, then it becomes a useless tool to monitor anything, and the whole thing falls apart at that point. But if you adopt that attitude from the start, I would imagine that every job that you work on will end up with a problem further down the line, because that's the whole point that we're trying to get across here. The contracts are not written there to be an adversarial, beat people over the head with it. They should be used as a means of flagging up problems, and both parties are there to help resolve it and deal with it early, as opposed to wait until it's a big problem and it's a big fun fight at the end of the job. So I know that's probably not answering your question, but the issue about the critical path, it's important that that is put into a contract so that everybody knows where the main issues are. But if it's missing, it just means that the process takes a wee bit longer to justify. But it can still be done, but it's important you do it at the time and not wait to try and go back and do it retrospectively. That's very difficult.
Yeah, thanks, Ian. I think you're spot on there. As you say, it can still be done. It's more difficult to do absent a critical path. But you know, those words we don't often hear in construction. A little bit of common sense over, in reality, what's happened here, what has the event caused a delay, and what is the impact? And it's really on the contractor to prove that. So,
Okay, thank you. And folks, if you have any more questions, we've got 2 in at the moment, but please use this as an opportunity to fire them into us. We've got about half an hour on the webinar, so pile in anything you want. They're all anonymous, so.
There's another one just come through, Len, that I think it'd be good for yourself, being that you've discussed the sort of time limitations or expectation for the CA or them, you know, for whoever's to make the assessment. And the question is, what are the consequences of not responding to an EOT within the 12 weeks and the loss and expense within the 28 days? So what happens then? Good question.
Difficult question.
Mm-hmm.
Imagine, first of all, what you have is a crystallized dispute. And you're only, well, if you can't negotiate something from the architect or the CA on it, pointing out that they'll fail to comply, I can only see a route as referring the matter to adjudication with great regret.
Mm-hmm.
And it would be with great regret that the design team didn't actually comply with their obligations. So I would be waiting until midnight on the 12th week. I would be giving them a nudge all the time saying, we've submitted our claim, we're happy to come and talk to you. Is there any further information? Don't just sit and do nothing. But at the end of the day, if you don't get any response whatsoever, I can't see any other alternative but referring it to adjudication. Gus, would you agree with that?
I would agree, Len. I don't think there's any sanction under the contract. You know, it's not as if there's a deemed acceptance or something like that of the contractor's claim if the 12 weeks expires. Unfortunately, you know, silence is not acceptance under these contracts. And I'd agree with Len that you're almost being jumped into a position where you're in a dispute. Yeah. But, you know, always talk, try and get some sort of agreement. If you can get an agreement on time, it opens the door to your payment. So it's entirely in the contractor's interest.
It's maybe just worth mentioning this. The ethos of the CICV forum has been to change the culture in the industry, to make it a far better place for all of us. We don't want millions of pounds worth of disputes. You don't want to be paying a lot of money to somebody like me sort these issues out yourselves. But we all feel very passionately that this is about making the Scottish construction industry a much better place to work in. So you shouldn't be facing a situation that you haven't heard from anybody.
And another question, just then, since it's sort of reasonably topical and it's related to these subjects, and the question is how to support an extension of time claim for loss of the good weather season due to the COVID events on a civil project, depending on suitable weather conditions for earthworks, etc. And I think that's back to issuing the notices timelessly, relating it to the correct relevant events, and demonstrating with the aid of records, possibly historical records, as to the weather conditions and the difference in productivity rates that you would achieve in wet weather, particularly with something like earthworks, when you compare it to the dry season. It's quite a common basis for claims, the change in the season.
Right. Well, I'm glad you answered that one because it was too difficult for me.
Not at all, the master himself.
Let's move on to Angus Pearson's guide to be successful with your claim.
It's a very, very short slide, this one. Yeah, things that, in order for your claim to have any prospects of success, obviously the notices, you've heard us all bang on about those. You must have your notices in play, correct form of service, correct substance to the right person, etc. Notices, notices, notices. It's as important as records, records, records. It's for you to evidence the causes of the delay and who was doing what and when, how was that impacted, and how do you record that? I'm becoming an increasing fan of the video evidence and the use of GoPros strapped to the hard hat. Somebody walks around the project fairly regularly and gives you a narrative explaining what's happening or what's not happening. Use this technology. There's also other multimedia platforms out there that can record the project from start to finish. There's a very clever system, without plugging any names, other systems are available, but Multivista is one such system that relates the drawings on the project to timeline and time-lapse photographs and things. It's an incredibly useful system, but probably only more appropriate to larger projects. Keep your programs up to date, mark them up. When you get a delay event, slot it into the program. How does it affect that activity and then any subsequent activities? Mark that up, submit it, note the extent of delay, update your notices and say, 2 weeks ago we said it was going to be a 6-week delay, it's now going to be 7 weeks. Keep the information flowing. The more evidence you're able to include within your schedule of evidence, the more likely it is that your claim will succeed. And presentation is everything when it comes to a sensible claim. I'm sure both Len and Ian will have come across the thrown together claim where it's just reliant on a big bag of notices and documents. There should be a nice, clear, crisp narrative. Sometimes I prefer to call it the statement of cause and effect, just explaining what the events are, when they occurred, how they impacted those particular activities, and then cross-reference that to the evidence that relates. Make it easy for the decision maker, whether that's an architect, a CA, or an adjudicator. Help them decide what that extent of time and or cost should be. That's all I've really got to say. If you follow those sort of tips, then you'll be in better ground.
Okay, we'll finish with
we're going to talk about the costs part.
Yeah.
Again, can't just be guesswork. You can't just say we're delayed, it's 500 quid a week, thanks very much. You're going to have to evidence your costs with proper vouching. Sometimes it's going to be reliant on wages sheets, sensitive information, it's sometimes good to get the other side to come and have a look inside your accountant's drawers, so to speak, rather than put stuff out there in the public domain or around as many parties just to sensitive commercial or personal information. Recovery of overheads is another thing that got much contention when it comes to valuing a claim. There's a number of formulaic versions. There's Hudson's, Emden's and Eichley formula, which some of the participants will be familiar with. These are useful, helpful, but they're not evidence of actual costs incurred, which is a sort of standard you'd really have to meet, particularly for any kind of Scottish tribunal. I always find it helpful to get a statement from the company accountant or the company auditor, even better, to state what the company's overheads are, and then you can always have a discussion with them and see if that's a sensible figure. Again, do a bit of diligence before you go into contract with people. Understand what their operating overhead is, or better still, have it declared at the start of the contract so that it's not a matter for discussion in the event that there is a claim. And again, another old favourite here, measured mile, pretty much relates to the question that Ian was asked there about how do you measure delay or the effect of a delay event when you don't have a critical path. Well, the measured mile analysis is going to be useful to show that you could achieve what you'd set out in terms of productivity based on the norms you've used for the works that you've put in the programme. You've priced the work based on a certain output, given normal circumstances and all the rest of it. If you can show that that was achievable, you've then got something to compare the impacted scope of work against. So if something should have taken you 2 weeks, but for that relevant event, it's now taking you 4 weeks, well, you know, there's a good argument there in some science to say that productivity is down 100%, and it opens the door for you to claim some recovery on your labour costs. So these are fairly run-of-the-mill type exercises that, you know, a CA is going to need to see to make those assessments, or a QS, and certainly an adjudicator if you're going to successfully prosecute your claim.
Okay, thank you. So just to summarise, when a submission comes in front of an adjudicator, what are the reasons that you're not successful? Or you're not successful when you talk to the design team? We've hammered the notices bit to death in this discussion. Detailed records and substantiation is absolutely critical. Some of the issues that you see are over-claiming, claiming for something that's not been done, claiming for costs that have not been incurred, claiming for subcontractors' costs which have not been paid. With the structure of the industry, a subcontractor might make a claim to a contractor who passes it up the line to the employer. Now, my view on this is as follows. If it cannot be demonstrated that the contractor has actually incurred these costs, then my view is he's not entitled to payment. If it's a contingent situation, if we get paid this, we will pay Mr. Bloggs. That is another matter, but often I have seen a number of claims put forward claiming sub-base figures which are different from what the sub is claiming. They've been exaggerated, and they've not been paid at all. And in fact, in a number of instances, I've seen a counterclaim against the subcontractor for delay. And adjudicators will investigate these things. They've got very wide power. And if you've got a nosy adjudicator, he or she will stick their nose into it and get under the rocks and stones to see what's there. You quite often see evidence of double counting. Often it's just an arithmetical mistake. You quite often see that vouching of costs have not been incurred. You know, it's not sufficient to say, here is a material invoice for 500 quid. You're going to have to provide proof of payment that you've actually incurred these costs. That's what the word means. Recovery of head office overheads, that's taken up a lot of thinking over the last 25 years in the industry. There's a very good case that Gus reminded me of it today called Walter Lilly. You can download it from the TCC website, but it's a very interesting analysis by the courts in relation to the recovery of head office overheads. There are certain hoops that you've got to go through there. For example, you might have to demonstrate that but for a delay in a contract, you had to turn down tender opportunities. You have to actually demonstrate that was the case. So there's a big hurdle there in getting overhead recovery. To me, there's a lot of logic in saying, well, we weren't able to move our resources onto another project, so we were denied the opportunity to recover overheads. You quite often see a claim where the contractor says the QS spent an extra 2 days a week on this site for 52 weeks. The managing director was involved for 3 days a week. Have you got a diary? No. Have you got timesheets? No. Where did you get the information? It was my best estimate. That will fall by the wayside. So it's up to you to keep the time involved. Just to finish on these 2 points, recording disruption is one of the most difficult issues, and I'm going to ask Ian and Gus to comment in a minute. You really do need to have a very detailed method of recording disruption on a project. And I've been looking at something over the last few days where the contractor was able to identify individuals that were working on a project that had to be moved from a work face because they couldn't get access, and they stood and did nothing. And that was all very carefully documented and wasn't disputed. So that's the level of detail that you need to get into. You quite often see a claim, total hours tendered, total tender hours, total hours, less total tendered hours equals the disruption. There's no recognition there of reworking. There's no recognition of somebody maybe not pulling their weight. I mean, I've got into a couple of sites recently and there was a bloke sitting on a table reading the Daily Record at 11 o'clock in the morning. Nothing to do with me, but you've got to recognise these things and knock some of that out. So that's a difficult one. Anyway, Ian and Gus, starting with Ian. Ian, what are your thoughts about recording disruption?
As you said, it's very difficult. The only way, surefire way of doing it is to record it at the time. Trying to do it retrospectively is just about impossible, because obviously, as you pointed out there, Len, just taking one set of hours away from another doesn't effectively give you disruption, because there's other factors that could be in there. There's also issues about whether what your tender hours were right in the first place, etc., etc. So there's a whole thing about it, and it basically comes across what's basically come out on all the slides in this webinar, is that recording the detail at the time and potentially submitting it, at that point in time, is the only surefire way of getting it agreed at the point you can demonstrate it accurately at that point in time. Anything you do retrospectively, it's basically produced with the power of hindsight, and sometimes you can see these presentations being presented in a manner that paints a picture that wasn't reflective of what was actually happening on the site. So it is about keeping the records and making sure the records that you've kept all along are going to be able to be called upon further down the line. But if it's done at the time, and as I say, I think you've pointed out, video evidence and such like is becoming more and more the norm, photographic records, etc. All these particular aspects come to the fore, but it is about recording it as they go and not trying to prove the case after the event. I think that's the one lesson I would take out of it.
Okay. Gus?
Yeah, I think I agree with you both, obviously, but the thing that when you know your project's being disrupted, it's really on the contractor to put in place a very robust recording regime, more than just who's on site, who are the visitors, what was the weather like, the typical records. You're going to have to get down in the nitty-gritty here and have as many of the individuals that are on the park maintain their own daily record sheet, not the newspaper the chap was reading in the canteen, Len, but a record of what they were actually doing, what area they were working in, what impacted their work that day. Now, it's historically, we've had it in a few big projects that have experienced serious disruption. It's difficult. You have to drag the operatives kicking and screaming to spend the 2 minutes a day to fill in a form in that effect. But you'll know better than I, Len, when it comes down to records and information, when it comes straight from the horse's mouth, the people on the park that were disrupted, then that kind of record and information is probably most likely to butter an adjudicator's parsnips than anything else you can come up with after the event. So,
I would mention I have a client who's a major steel contractor, and last year they had a major problem on a job in the south of England, and they put together a computer. I don't know how you describe it, but it was an absolutely amazing. They were able to show variations to the contract floating in and where it was put in and how it was disrupted. And to be honest with you, it was an absolute no-brainer. When it was presented to the main contractor, he just said, hands up, we're stuffed. We'll have to take these issues up with the employer. So I think there's an increasing use of technology. Gus, you don't think so?
Most definitely, Len. And there's an awful lot of sort of multimedia companies out there now who specialize in producing claims and trying to, it's the old story, picture speaks 1,000 words. Well, a video goes further. I've seen a couple of them myself, and when they're pretty polished and pretty slick, then, it's everything in one place and you can reach a decision on them fairly quickly. There's a downside, they're expensive, but it's all in relation to the sort of numbers that you're claiming. But certainly that technology, having seen it work, it is pretty impressive stuff. It's very powerful.
Okay. Right, we've got a few questions. Just before I ask us to read them out, I've had one come in to me. Would Mr. Bunton please explain his library? Library are the chapters in my forthcoming book, How to Spend 45 Years Trying to Change the Scottish Construction Industry and Failing Miserably. So it will be on the market in the spring of next year if you would like a copy. I think there's 7 questions in. I think we've done 3. Can you pick them up?
Yeah, we've dealt with 3 or 4 so far. Here's one for, well, I'll put this one to Ian first. What are your thoughts on Hudson formula, Ian, in relation to value and delay and loss of profit? I don't know if the author, I don't think it's appropriate for loss of profit, but it maybe means loss of overhead. What's your view on the Hudson formula, Ian?
I mean, it has always been a contentious issue in terms of proving what overhead recovery and such like, because obviously overhead recovery linked into an individual specific project is variable dependent to a certain extent on the turnover of the business and the amount of work that they've got on and all the rest of it, and indeed whether the jobs that you've got on are actually profitable. But I mean, my feeling on all these sort of things is that if you've identified the specific costs for running a site, for example, in your prelims and everything else, then there's an element to be able to demonstrate that there is any kind of overhead recovery in your tender in the first place. And that's an area which causes grief no matter what we do. I think that at the end of the day, if the individual job is basically adding profit into the system, contributing to overheads, then obviously that's obviously the intention on all this stuff. But you can end up with overhead costs being allocated depending on individual companies. So it's not a, I don't necessarily agree with this, the principle of that as a standard approach across the whole thing. We've got to be horses for courses, because every business has got a different model for how they actually put that figure across. So I wouldn't necessarily agree with it as being the overriding way of dealing with overheads.
Thanks, Ian. Len, your view on Hudson's?
To be honest with you, I'm reluctant to give a view for obvious reasons that people on this call might have a situation where I'm an adjudicator in the future. So I'm reluctant to express a view, other than to say that I've had a number of decisions where the recovery of head office overheads was properly and very well articulated, including reference to case law, and I found in favour of the contractor in those instances. So it depends on the circumstances, and I think it depends on the way in which you actually argue your case. Sorry not to be more specific.
No, thanks, Len. I think everybody would understand that. It's back to that. It's a formulaic sort of theoretical assessment, and you know, it doesn't really discharge the burden of proof when you're trying to recoup a loss. That's my tuppence worth on it. I'm just looking at the questions. What else do we have? We've dealt with the issues on the programme. There's a later one there. Oh, the anonymous attendee. This is a good question. What is the definition of as and when it becomes reasonably apparent if a delay is encountered and the contractor uses best endeavours to mitigate, but later realises that it's not going to be possible and then submits a delay notice several weeks or months later? Should this still be considered by the architect / CA, or could this be considered invalid as not notified at the time when the delay was actually encountered? Very good question, and let's have Mr. Bunton have a go at that one first, please.
Well, let me just think about it. I think it's an evolving process. You have to recognise that. And information may come to light, or a delay may impact on a whole load of different circumstances. You may start off with a particular line of argument and find it changes due to circumstances out with your control. So I don't think you could safely knock something like that out. It's one of these it all depends scenarios. I don't think I can really add much more to that. I mean, I've experienced that myself. Contractor thought he was going down a particular route. It all changed because of the impact of other delays on the main delay that he was promulgating. So it just depends on how the thing washes out, I think, yes.
Ian, any view on that particular? Have a think about the best endeavours part of that to mitigate.
I mean, I think the answer about when it becomes reasonably apparent. I mean, if something comes to mind that you anticipate there's a delay, there's no harm in sticking a notice in. What happens with that notice at the end of the day is kind of part of the process, if you like. But if you don't put the notice in saying we think we're delayed, then you've missed the boat. So my view on it is you can have any number of notices going in, whether they actually result in anything at the end of it is as Len's saying, is subject to what happens thereafter. I think that the language that's used in a lot of SPCC and contracts and such like is a bit woolly anyway. When it does become reasonably apparent, it might be reasonably apparent to a subcontractor, it might be reasonably apparent to a main contractor, it might be reasonably apparent to an architect or a contract administrator at a different time, if you like. But it's when it's reasonably apparent to you, and if you think there's a potential for it to delay, my view is you should stick the notice in, and it's in, and you've put a line in the sand. What happens thereafter will be part of the process, as I say, and it may manifest itself in an extension of time or such further down the line, or it may not.
Yeah, I think you're right, Ian. It's always sensible to issue the notice anyway. If that becomes part of a subsequent claim, so be it. If the notice just withers on the vine and disappears, no harm done. So
I think it's very much like the NEC early warning process. If you see something looming on the horizon, which may or may not materialise, flag it up. If it disappears, fine. If it doesn't disappear, you've given the appropriate notice.
And the other point there about best endeavours to mitigate, you know, you notify a delay. Let's assume that you have notified it at the correct juncture, and then you use your best endeavours as you may well be obliged to under the contract, and you actually get rid of the delay. There is no delay. I think then you would have to issue a notice in relation to a relevant matter around that to recover your disruption or loss of productivity or overtime acceleration costs, whatever it may be. So there's no one size fits all answer to the question, but I think stick with your notice, records, and do your best to explain the actual impact on your work.
Yeah.
I think that's about it by way of the questions, really.
Let me just comment on that last question.
Of course.
Where you need to have a grown-up conversation with the employer, contractor, and design team. And there is absolutely nothing wrong, in my view, in the contractor saying, look, there's a potential delay looming, but if we do X, Y, and Z, we can circumvent that, and there'll be a financial implication of that, which might be significantly less than the financial impact of the initial delay. So have a conversation and face up to the realities.
And that is a very important point, Len, because I don't know about you, certainly in a number of claims, it always gets thrown back over the fence. Well, what measures did you take to mitigate? Were they your best endeavours, and then the argument of the difference between reasonable endeavours, best endeavours, all the rest of it. A responsible contractor or employer, it shouldn't be standing there looking at a contractor struggling and then come back and try to use the obligation to mitigate as a means of defending the claim. If you don't believe that contractor is doing what he should be to mitigate the delay, it's on you to get them told. I see it too often where it just comes back as an excuse, as a defence to a claim, whereas more collaboration, if you think they should be doing something else or something further to mitigate that delay, tell them, even instruct them, use your contract. So that's my view.
Okay, well, we're 2 minutes past our completion date. So first of all, our presenters,
get the notice.
The communication folks in the forum, they've put on a fantastic presentation again. The next session will be an interesting one. We have Professor Rudy Klein, myself and Matt Henderson, who's a business recovery specialist, looking at suspension and the implications of terminating your contract and the implications of contractor failure. So I encourage you to attend that. But importantly, the last one will be very significant because the presenters will be looking at the pitfalls of adjudication, how to get around that, and the RICS conflict avoidance process, which puts into place a mechanism that stops all these things festering and boiling up. So hope you can attend. So thanks, folks, for your participation, and thanks to Ian and Gus for their contributions. Stay safe. Bye for now.
Yes.
Thank you all.
Bye.